The New South Wales State Government announced the creation of 19 new local councils in May this year. Despite significant opposition, over 40 councils were dismissed and administrators installed to run the new councils until elections are held in 2017. While the idea of democratically elected governments being sacked in this way might seem shocking, it is well established in the Australian system. This is because the legal status of local and state governments are quite different. States are recognised in the federal constitution, local governments are not. This means that councils are much more vulnerable than state governments. Legally, local governments are created by state governments. As in other states, the New South Wales Constitution makes it very clear that local government is subordinate to the state. Local government in New South Wales is regulated under the Local Government Act of 1993. This sets out what local governments must do, what they may do, and what they must not do. It also sets out how councils can be established and, importantly, how they can be altered. Legally, it's clear that the state can force local councils to amalgamate, and there have been many amalgamations in New South Wales over the years. In 1906, when the first Local Government Act was passed, there were over 300 councils. These have been reduced through a series of amalgamations, including several on a scale comparable to those currently underway. Around 40 councils were cut in 1948 and again in 1981, each time replaced by around 20 new councils. There have also been a number of voluntary amalgamations, including 5 new councils formed from 10 existing areas in 2000 and 2001. The disputes and litigation about the current amalgamations do not challenge the basic idea that the state can make and unmake local governments. Rather, these challenges are about the process, whether the state followed the procedures set out in the Act for things like studies, timing, and public notice. There have been debates for many years about recognising local government in the federal constitution. The issue went to referenda in 1974 and in 1988, and would have done so again in 2013 had the election followed the schedule set by Julia Gillard. However, the issue at stake then was relatively minor. Even if it had gone ahead and had been successful, it would not have prevented the amalgamations. To protect local councils from state government would require a major constitutional change.